Hi, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GC subs and suppliers. We're a national construction document service. Today, we have a great webinar on getting paid faster in Arizona with liens, bonds, and contracts by the amazing construction attorney, Kevin Estevez. Without further ado, I would like to introduce Kevin Estevez.
Thank you, Diana. As Diana said, we're going to talk today about getting paid faster in Arizona with liens, bonds, and contracts. And some of this will be a refresher on some of the topics we covered earlier this year. And then there's some new information in here as well. So with that, let's get started. If you have any questions during the webinar, please use the chat box on your screen, and we will answer the questions at the end. Please do not include your name or your company name in the questions. And with that, let's jump right in. So the first thing to do to ensure that you get paid in Arizona, and I thought this is of particular importance for a couple of reasons, is make sure you're a licensed contractor. Make sure you have the right license to do the work, because that, as we'll see here, can be an ultimate bar to payment. So first reason to be a licensed contractor is you're required to by law. And as you see here on this first slide, it's a class 1 misdemeanor under 321164 to not be. And so pursuant to ARS 321151, it is unlawful to engage in the business of, submit a bid, or respond to requests for qualification or a request for proposals for construction services as act or offer to act in the capacity of or purport to have the capacity of a contractor without having a contractor's license in good standing, unless exempt as provided in this chapter. And there are a few exemptions. One is a handyman exemption for work under a relatively small amount, but in almost every circumstance, you need to be a licensed contractor to perform contracting work in Arizona. And as this relates to payment, look at the next bullet point here on the slide. 321153, ARS 321153 provides that no contractor shall commence or maintain any action in any court of the state for collection of compensation for the performance of any act for which a license is required without alleging and proving that it was a duly licensed contractor when the contract sued upon was entered into and when the alleged cause of action arose. So if you're not a licensed contractor when you entered into the contract, and you're not a licensed contractor when you perform the work, you cannot use the courts in Arizona to collect monies that you may otherwise be owed for work that you performed. So the first step to getting paid faster is to make sure that you're a licensed contractor and you're licensed to perform the work in question. And that way, if you don't get paid, you have legal recourse to pursue those funds that you're owed. The next thing, and this is something that we touch on in all of these webinars, and it is one of the most important steps you can take in Arizona to ensure that you get paid for work that you perform or materials that you provide, and that is to serve a preliminary 20-day notice. Except for laborers for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work. And we'll talk about both lien claims and bond claims and how the 20-day notice fits into both of those. But as a general matter, you want to make sure that you serve a 20-day notice in Arizona. That will protect your rights in most instances to getting paid. What happens if you don't serve a 20-day notice? You can potentially, well, if you don't serve a 20-day notice, you will forfeit all lien rights. If you do not serve a 20-day notice, you may forfeit bond rights. And then if you don't serve a timely 20-day notice, you forfeit a portion of lien and a portion of bond rights. You can do those as well. So it's not only serving it, but you got to make sure that you serve it timely. And what do 28 notices do? And we've talked about this in the past. They give the owner advance information of the identities of any unpaid claimants who may perfect liens or in a bond situation may make a claim against the bond. And that situation, the notice goes to the general contractor who posts the bond. If debts remain unpaid and satisfied. So generally speaking, they put either property owners or parties that post bonds on notice of folks out there that may be seeking payment in connection with a project. So this is a recap on our previous webinars from last year, but how do you preserve your lien rights in Arizona? We just talked about it. You serve a proper preliminary 20-day notice. You don't forfeit your lien rights by signing an improper and or incorrect lien waiver, and that was the subject of our last webinar a couple months ago. When you get lien waivers, be careful with what you sign. Arizona has a statutory scheme for lien waivers. We have a statutory conditional progress waiver, a statutory unconditional progress waiver, a statutory conditional final waiver, and a statutory unconditional final waiver. Be careful with what you sign. And then the last thing to preserve your lien rights is to timely record a statutory compliant notice of claim of lien in the project, in the county where the project is located. What happens after you record my lien? And with respect to timing of recording liens, you can go back to our past webinars and we set up the timing parameters there. We talk about those in those past webinars. But after you record your lien, you must timely serve the notice of claim and lien. You need to be on the lookout for lien discharge bonds, and then you must sue to foreclose the lien within 6 months of recording it. So you really have a short window to file suit, and then you must record and list pendants within 5 days of filing suit. Payment bond claims. So the subject for today is how to get paid faster with liens, bonds, and contracts. The next topic we're going to touch on here is payment bond claims and the notice requirements. So under the federal Miller Act, laborers and material men with no direct relationship to the general contractor furnishing the bond must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last of materials for which the claim is made. So those are on federal Miller Act bond projects. So the notice requirement there is those that don't have a direct relationship with the general contractor posting the bond have to give a 90-day post-completion notice. And one thing to be mindful of when you're thinking of completion, completion with respect to liens and completion with respect to bonds is a little bit different. Completion for lien statutes is completion of the entire project. Completion for bond statutes is completion of your work or the furnishing of your materials on the project. So we just touched on the Federal Miller Act, Arizona's Little Miller Act. Any claimant who has a direct contractual relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship expressed or implied with the contractor, has a right of action on the payment bond on giving the contractor the following notices. So if you have a direct contractual relationship with the party furnishing the bond, the notices aren't required in Arizona. If you don't, you have to serve a preliminary 20-day notice that we just talked about a couple slides ago, and then you have to give a 90-day post-completion notice. And this slide right here talks about who's protected. And so you've seen this slide in some of our previous presentations, but when you have the general contractor posting a bond, the first tier subcontractor and the first tier suppliers are protected without notice. Then the second tier subcontractor and the second tier supplier are also protected, but both under the federal law and under Arizona law, they have to give notice that we just talked about, the types of notice we just talked about on the previous slide. And then the folks in red here are not protected. So that's a brief overview, a brief recap of both how to protect your rights under Arizona's lien statutes and how to protect your rights under applicable bond statutes. I'm going to talk now about Arizona's Prompt Pay Act, and this is another way to ensure you are paid timely, and it relates to the third component of our presentation today, which talks about getting paid faster with contracts. So as a general premise, Arizona has multiple prompt pay acts. We have a private sector and a public sector prompt pay act. ARS 286924, ARS 412577, and ARS 34221 govern public construction projects. Those are the public prompt pay acts. And then 321181 governs private projects lasting more than 60 days with the following exceptions. So 321181 EDSEC are Arizona's private sector prompt pay laws, and as you can imagine, those are the ones that are most frequently in play in Arizona. So with the two exceptions to the applicability of the private sector prompt pay laws are they only apply to residential, i.e. owner-occupant projects, if the contract with or invoices to an owner-occupant contain notice that the prompt pay laws apply. And the parties can alter the billing cycles provided for in Arizona's prompt pay statutes, but to do so, it's not so easy. You have to, pursuant to the statutes, provide for a different payment schedule in the prime contract in a clear and conspicuous manner, and to place a statutory notice of alternate billing cycle on every page of the construction and bid plans. And you may think that's an onerous requirement, but the reason that's put there is that so subs who bid on the project, when they are looking through the plans and compiling their bid, they have noticed that the billing cycle is different than they're typically accustomed to in Arizona. So this is a quick overview of the timing provisions in Arizona's public sector prompt pay laws. And just as a general matter, both the public sector and private sector prompt pay statutes provide for a 30-day billing cycle with a little bit of a distinction or difference. So in the public setting, the owner receives the general contractor's invoice. It has 7 days to review and approve it, and then it pays 14 days later. Then the general has 7 days to pay the subs, and then the subs have 7 days to pay their suppliers and or subcontractors. The standard billing cycle on private projects, again, it's a 30-day billing cycle, but the one distinction is that in a private setting, the owner has longer to approve the invoice. So whereas in a public setting, the owner has 7 days to approve and 14 days to pay, in a private setting, the owner has 14 days to review and approve an invoice and 7 days to pay. Its general contractor, then again, the general contractor has 7 days to pay its subs, and the subs have 7 days to pay its suppliers or subcontractors. And one thing to be mindful of with respect to the private sector prompt pay laws is that owners have 14 days to review and approve, and if they are going to object to a payment application, they must do so in writing, and they must do so within that 14 days. If they don't, it is deemed certified and approved after 14 days. So again, key provisions of the private sector prompt pay laws. Standard billing cycle is 13 days. Owner has 14 days to approve pay applications and 7 days to pay. contractors and subs have 7 days to pay after they receive payment. Pay the folks downstream. You must object in writing, and this, pursuant to our statute, sums that aren't timely paid under the prompt pay statutes bear interest at 18% per annum. So with that said, let's talk briefly, because I know we've been going for a while here, about a couple contract provisions or a couple things to be mindful of with respect to contracts. Now, as I'm sure folks in the industry know, construction contracts come in all shapes and sizes, and the provisions that you can run into that affect payment are numerous, and anyone faced with signing a construction contract in Arizona that they're not sure about should consult with a qualified attorney regarding the particular provisions in the contract. But having said that, a couple things to bear in mind. As we talked about, Arizona provides for a general 30-day payment cycle under our prompt pay statutes. As we also talked about, those timing provisions and that 30-day billing cycle can be amended. And as you saw a couple slides ago, it's a lot of work to amend it, but it can be. So one thing that generally folks that want to get paid promptly should be mindful of is to know and to avoid contract provisions that are less favorable than Arizona's prompt pay laws. Arizona's prompt pay laws keep the payment they're signed to, and they're relatively successful in keeping payments flowing on a project. So if a subcontract provides for payments in a less timely manner than under Arizona's prompt pay laws, there may be a question whether that's enforceable or not. But generally speaking, if a project provides for an alternate billing cycle, that'd be something that you should probably seek to avoid as a contractor or subcontractor. The second element, and again, when you get to construction contracts, there's numerous provisions that affect payment. One interesting clause that if you are a subcontractor is sometimes hard to swallow is a pay if paid clause. And just generally speaking, pay if paid clauses are clauses that make a owner's payment to the general contractor a condition precedent to the general contractor's obligation to pay its subs for work performed. So it's a provision that you'd find in a subcontract that says that, hey, as the general contractor, we don't have to pay you, subcontractor, until we get payment from the owner for your work. So it shifts the risk of owner non-payment from the general contractor, who's the party that deals directly with the owner, to the subcontractor, a party that's not in privity with the owner. And there is an Arizona case. L. Harvey Concrete is the seminal case in Arizona that addresses pay if paid clauses in construction contracts. And L. Harvey holds that those clauses are enforceable, and it provides for that they are enforceable. Well, first of all, L. Harvey says there's no magic language required to have an enforceable pay if paid. But then the court basically breaks down why the pay if paid clause at issue in that case is enforceable. And so that has sort of become the litmus test for whether a pay if paid provision is enforceable. So pursuant to L. Harvey, a pay if paid clause that states that payment by the owner is a condition precedent to the general contractor's obligation to pay the subs. If it says that, it's on its way to be enforceable. Number two, if it states that payment is not due and owing until the owner pays the GC, that was another element of the L. Harvey pay if paid provision. And third, it identifies the owner's payment as the sole source of funding for the subcontract. So pursuant to L. Harvey, pay if paid provisions that have that language in them are enforceable in Arizona. And I say that with one caveat. There is a potential wrinkle to that. And so you see the last bullet point here that says that it's important and it's unsettled in Arizona whether the Prompt Pay Act that we talked about just a few moments ago bars pay if paid provisions. There's a provision in the Prompt Pay Act that says that nothing in the act prevents the party from getting paid from the other party with whom it contracts. And so there's an argument that's never been addressed whether or not that provision bars pay if paid provisions in general. But as of right now, under El Harvey, those provisions are enforceable in Arizona. And so if you want to get paid quickly in Arizona, and if you want to avoid payment hassles, particularly if you're a subcontractor, you want to be mindful of pay if paid clauses. And with that concludes our presentation for today. As always, Arizona statutes and case law relating to the construction industry are full of detailed technical requirements and exceptions. This presentation cannot substitute for specific legal advice. If you have questions and concerns relating to a mechanic's lien, a payment bond, or construction contract, please consult a qualified attorney. And with that, we'll take any questions.
Kevin, we do not have any questions at the moment.
Okay, then I think we can wind down. Please take a moment to review this presentation. There's a link here on the screen, and with that, I think we're done, Diana.
Yes, sir. If you have any questions, feel free to give us a call or send us an email. We'll be here to assist. And thank you very much, Kevin. And thank you, everyone, for your time.
Thank you, Diana. Thank you, everybody.